And we have some amazing speakers here, and so we've given a lot of time both for people to share their views and for you to speak with them about the various issues that we've raised, and we've deliberately created a lot of space for discussion. And to enable that process to happen, Alex Mead is going to be moderating the session. And I just want to say a couple of words. Of course, he needs no introduction in terms of his public profile. His role as Secretary General of Amnesty International is well known. I know that many of you see him and read him in the media and watch him on TV, hear him on the radio. But I also want to say that Alex has been a stalwart supporter of enabling many civil societies, not only Amnesty, not in a just sense, but in an only sense. He is also one of the co-founders of the Voices-Voix movement, understands the deep connections between and among civil society organizations, how to make them happen, how to make sure that people are supported, and has been a really indefatigable supporter and activist for many of the organizations in Canada that so much need the support of apex civil society organizations like Amnesty that can provide incubation, if you will, support, leadership, introductions to funders, introductions to and lobbying with government supporters, access to people who, for many smaller civil society organizations, we simply do not have. And so I think that's another piece of the enabling toolkit, if you will, that we often don't think about, but the role of apex civil society organizations in providing that space is fundamental, and Alex is a leader in that regard in Canada at an interpersonal level, at a professional level. I'm very proud that he's here with us today.
Well, thank you, Pearl. That's a very generous introduction, and I've decided I'm going to take two of your words and add them to my business card. I'm going to be an apex incubator. But I'm really just look at this, eh? I mean, pretty impressive. This is going to be a great session, very dynamic, and flows wonderfully from that session that Julia so ably steered, and the great things that we heard from Mary and Ravi and Nicholas across so many different issues and different perspectives. And obviously that first panel was, I guess, in essence about the why enable civil society. Why is that an important imperative and goal and need? And now we're moving to a different question, and it's the question of if civil society is enabled. It isn't here in Canada. It's kind of notable that we have to ask that question, and then we have to have a panel that has that kind of focus. Certainly probably from an outsider's perspective, outside of Canada, if you put that question, civil society isn't enabled in Canada, and probably, I'm guessing maybe 9 out of 10 would say, of course it is, absolutely, must be, more enabled than anywhere. But we're having this session because there's certainly a very strong au contraire element to that conclusion, isn't there? I mean, obviously you all, from the various perspectives, academics and activists, know that firsthand, absolutely. It's absolutely essential that we turn ourselves now for this next good chunk of time to really looking at that question, exploring it, going underneath it, looking at that question from a variety of different perspectives. And it's important that we do so for any number of reasons. Certainly, it's number one, it's important because it's inescapable. I mean, we're having this conference in Canada. We're active in the Canadian scene in all of our various different ways, and this is our reality. This is our context. So of course we want to need to be exploring it. But secondly, and I guess in a more critical way, as I think everyone in this room knows, and it's come up several times in both direct and indirect ways in earlier comments, we've been on a bit of a journey in Canada over the last X number of years. I think everyone has their own euphemisms for what they call it. I refer to it as the dark decade, but there's all sorts of different aspects to that journey. Remembering, and I think very importantly that came out in the first panel, that it's not to suggest that we were in any state of perfection, going back to 2005 and sort of that utopia suddenly came undone. Clearly not. But we do know that there were years of real struggle around this question, and I think some in this room experienced that firsthand. Their organizations and their advocacy causes significantly undermined and targeted. And one of the things that was so evident as we all were going through those years, and as the Voices Coalition and many other kinds of initiatives came together in response, I think one aspect of it is the disbelief. We were naively so, perhaps, but we were stunned that it happened, but also that it happened so readily, so easily. That it wasn't, it didn't involve the need for massive law reforms and sort of complicated policy changes, etc. The dismantling, the undermining, the targeting, the tools, the means, the openings, and the avenues to do so, they were all there. It was all right for the plucking. So certainly that's a key piece of why we're wanting to have this opportunity right now for this panel, is to think about that journey and where we're at now. Have we come out of it? Where are we moving next? What remains as ongoing challenges, etc. But I would also suggest that the third reason why it's important is, and things we need to see if this at all comes up with some of our presentations. We haven't deliberately thought this piece through, but there's a global piece to this as well. I think this is something we often have in mind when we're grappling with any human rights issue or challenge in a Canadian context. We want it to be better because it matters locally. When rights aren't being protected, when things are imperfect, flawed, that matters because it has impact and consequence locally and needs to be addressed. But there's always that global dimension, the sort of to lead the way, to set a model, demonstrate a better practice globally that we'd like to think we're capable of as Canadians, and in particular, I think, cherish, rightly, wrongly, sometimes with a bit of naivete, that particular idea when it comes to human rights issues. And I think this is a perfect example, again, of another area where that's an important part of why we want to be improving and strengthening and doing so much better in terms of how civil society is enabled in Canada. And that is because, my heavens, doesn't that need to happen globally? And some of that work begins with how we address these issues here. It's getting to the, the 5 stars that we talked to us about earlier. So here we go, off on that exploration of the question, does Canada enable civil society? We have 5 very accomplished panelists who are going to explore that question and share reflections. As we have 5 panelists, we're going to try to stay tight to time, but each of our panelists, and we were back and forth as to whether we were going to do really short opening interventions and then just move into an ongoing kind of dialogue, but everyone has something quite key and important and fundamental they really want to be able to share with you. So we are going to begin with no more than 10 minutes from each of our panelists. And the idea is that should leave us more than half an hour at the end for some back and forth and question and answers. And we are going to begin with Catherine Chan. You all have the bios, so I'm not going to take you through all the details, but just to remind you that Catherine Chan, sitting right beside me, is an assistant professor at the University of Victoria's Faculty of Law, where, amongst other things, she has an expertise in not-for-profit sector law. So obviously, a wealth of background and research endeavors and teaching and thinking, etc., both in a very Canadian context, but she's also done some comparative work that is directly relevant to the question in front of us. So Catherine, 10 minutes, go.
Thank you. Well, I could talk about this all day. One of the ideas that really emerged for me out of the panel this morning, which I really enjoyed, was this idea of laws being on the books, and then periodically through history, right, you have what we call the dark decade, or periods when, wow, those laws are actually being enforced. And like you said, I think partly what happened with the political audits and why it took everyone so much by surprise and happened so quickly is that actually all the pieces were in place. And what I want to say today is that really all those pieces remain in place. So I want to point just to 3 features of our regulatory regime. And I am going to concentrate on charities, but some of this applies more broadly to the nonprofit sector. That isn't a registered charity in our lingo. I think that ultimately are disabling features of our regulatory regime for charities. And I'm not going to talk about the political purposes rule in particular or the restrictions on revenue generating activity. I think other people can speak to this, to those things. I'm going to go very high level here and talk about 3 very basic structural features that I think we need to address or at least talk about. And the first is, so number 1, our charities regulator is an agent of the Minister of National Revenue. So for those of you who don't know, the Canadian Charities Directorate is an internal administrative unit of the Canada Revenue Agency. It has no separate statutory function or set of tasks or responsibilities. And so its mandate, like that of the broader CRA, is simply to support the administration and enforcement of the Income Tax Act. So that's the first point, right, that it is part of the CRA. Second, the Canada Revenue Agency, unlike revenue authorities in other parts of the world, which enjoy some level of independence from the executive branch, is a ministerial government department, which is subject to the direction and control of the Minister of National Revenue, right, a member of our cabinet. So this sets our revenue agency apart, charities directorate aside a little bit from, for example, the British tax authority and other tax authorities around the world. So why does this create a disabling environment for charities? Well, first of all, charities and their legal counsel are dealing, as I said, with the charity regulator that has no charity-specific mandate. And at the very least, that means that when a charity gets into a dispute with CRA, if you have a dispute between, say, the Charities Directorate and Equiterre or another organization, David Suzuki Foundation, counsel for Equiterre can't argue, for example, as you could in England, that the Directorate must exercise its discretion in a manner that is consistent with its statutory objective of increasing public confidence in charities, or of increasing innovation in the sector, right? None of that is written into the law. And second, the kind of complete lack of independence of our charities regulator does leave charities vulnerable to being audited, revoked, refused funding based on the particular ideology of the government, right? And that's what we saw with the political purposes audit. And it was very interesting because during that whole time, the then leader of the Charities Directorate, went on record several times saying that the Directorate was independent from the CRA, that it made all, I saw that was cited in one of your papers, right? And I'm not going to dispute those statements, perhaps as a matter of institutional practice. Maybe that was the case. Maybe that was aspirationally that was the case. But in law, the Directorate is an agent of the Minister of National Revenue. So that just has to be false as a matter of law. And actually we saw that because when the government changed, the new Minister of National Revenue ordered those audits to be suspended, right? So, and CRA did what she said because they had to, right? They are the agent. So that's thing number one. All right, structural feature number two. In most Canadian jurisdictions, there is no public person, public official, that acts on behalf of the public interest in charity. So we have largely inherited the English common law charities tradition, or at least the substance of it, but none of the procedures. And even in Quebec, because it's been incorporated into the Quebec tax code as a matter of practice, if not as a matter of law. In the English common law tradition, the Crown was recognized as having a superintending power over charities, which was part of the historic relationship of allegiance between the English people and the King. And what that meant was that just as the law of nature required that every subject obey and serve the king, so required that the king maintain and defend his subjects, particularly those that cannot defend themselves. And so children fell within that category, right, the traditional parents-patriarch jurisdiction, but also charity. And so when property devoted to charity was under threat by a negligent trustee, or perhaps by a greedy heir, the Attorney General would appear in the King's courts to defend the public interest in charity. And in the modern day, right, this role has been largely preserved, for example, in the English charity law regime. And so what that means, among other things, is that in England, when there's a dispute between the revenue authority and a taxpayer that relates to charity property, so that can happen there as it happens here, sometimes, or quite often, the Attorney General or the Solicitor General or the Charity Commission itself, which has a delegated authority in this respect, will often appear as a third party to protect the public interest in charity in courts. And this is markedly missing from the place where most of our charity law litigation takes place, which is in the Federal Court of Appeal. I've been in the Federal Court of Appeal before, once on behalf of the charity, and have actually been told, you know, you don't represent the public interest of charity, you only represent the client. And that made me think, well, no one is representing the public interest in charity. And there's a real, right, as you can imagine, power dynamic there that goes on when you have the state on one side of the room and, you know, the itty-bitty charity on the other. So that triangulated relationship doesn't exist. Well, I argue that there's a basis for it, but it doesn't play out that way in Canada. And finally, 2 more minutes? Yeah. Okay. And finally, third structural big piece is that our legislation governing regulation of charities is extremely thin. And I say that as a piece acknowledging that there are people who work in the charitable sector or that council that represent charities that, you know, would see that maybe it's good, maybe it's bad, right? That can be good, depending where you sit, right? That there's a light touch regime, that there are perhaps not too many rules, right? I think charities themselves are sometimes, you know, hesitant to go too far down this road because what if you end up with all this regulation that you didn't have before and life is suddenly more painful, more onerous. But I think we have to talk about this a little bit, right, in terms of the big picture. Canada's charity law regime is basically constituted by a dozen sections of the Federal Income Tax Act, known as the registered charity provisions. By contrast, right, the Charities Act in England and Wales is something like 370 sections. It took, I think, and I've read that it took more time to debate and to legislate than any recent piece of English legislation. So there are lots of things to talk about, including whether we should have a statutory definition of charity. We're on the dwindling list of common law countries not to have adopted one. And so why is this disabling? I think, first of all, means there's very little political discourse on what the sector should look like. I lived in England for a couple of years recently studying this stuff, and I can tell you that it is the case that many people on the street have some idea of what the law of charities entails, and we'll talk about things such as, should independent schools like Eton or Canada College or whatever, should they have charitable status, right? These are live political issues. So and we are largely still lacking in that political discourse, although it's improved since the audits. And second and finally, I think it's disabling, and this isn't talked about very much, but I think it's a big piece. It's disabling because the charitable sector is almost entirely governed right now by what I would call soft law. So by the multitude of policies and guidance documents and opinion letters and interpretation bulletins that the Canada Revenue Agency posts online. And if you are an administrative lawyer, you know that that kind of soft law is very difficult to challenge, right? And so we're in this funny situation where it's not law from the perspective of formal understanding of law for most judicial decisions, but it is law in the sense that it sets the norms that are binding on the regulated community, right? And that are understood both by the regulator and the regulated, I would argue, in the sector as being law. And so I think that's also a major challenge that we need to deal with going forward.
Great. Thanks very much, Catherine. We are now going to move on to Lisa Lalande. Lisa, as you can see in your materials, is the executive lead for the Mowat not-for-profit program within the Mowat Centre at the University of Toronto. So obviously has a great base from that, but she's also, as you'll see in her bio, worked outside an academic setting in the not-for-profit sector very directly, so brings that experience as well. So over to you, Lisa.
Thank you so much. And I just want to start by thanking you for inviting me to the process and for being here. I'm really excited to be part of this discussion and share a little bit about the Mowat and please take on this issue over the last year. So I wanted to just start. So the audit of political activities, and I'm not going to get into that too much because it was already shared as part of the material. And the advocacy show led to one of the most promising opportunities for political sector reform in more than 10 years. And the government, as you know, committed to strengthening the sector by focusing on the issue of public policy engagement and developing a new legislative framework for the sector. And while this led to the launch of the 2016 Political Activities Review and the Canada Report, it's really unclear at this point. So are we turning the corner? It's unclear as to what that will mean in the future. So our position is that the debate over advocacy efforts and definitions of political activity really brought to the surface systemic issues in the relationship that have been brewing for a very long time. And those that are very close to this are aware of it. And ultimately, some of this was touched upon in the earlier part of the presentation, but ultimately there's a kind of a lapse in overarching guiding framework that articulates that vision and shapes the relationship between government and sector. And we believe a framework is required to guide what sort of regulatory choices and trade-offs. So decisions regarding the sector can be, in our view, haphazard without them. And the budget of 2017 is a great example. There were no budget commitments directly to the sector, although there were specific budget commitments made to sector organizations. So then what should the relationship with the sector be, and what should be the institutional links? There was an accord that was created as part of a previous sector reform effort with the voluntary sector initiative. And it established an accord that outlines goals and guiding principles and responsibilities. But for a variety of reasons, it was really never picked up politically. There's also lack of harmonization across the provinces and territories. So So provinces have jurisdictions over charities, nonprofits are regulated provincially or federally. Within provinces and territories have their own legislative and regulatory frameworks, and there's a lack of harmonization on aspects of legislation and regulations such as transparency, information sharing, and corporate law. And there's a lack of role clarity and overlap of responsibilities. So provinces and territories play an important constitutional role in regulating nonprofits and charities. And CRA has gradually, in our view, filled an unmet need in providing policy direction on activities related to registered charities. But they don't have a mandate to strengthen and enable the growth and the development of the sector as a whole. And the issues, as we've mentioned, cut across multiple industries: finance, revenue, employment, workforce development, and labor. And there's ultimately a lack of capacity on sector needs to consult on sector needs and priorities that impact the ability to proactively engage in the policy dialogue, and ultimately how the sector participates in the democratic process. We believe that these issues constrain rather than enable the sector. So what does that mean on the ground? So we believe that in Canada, the charitable sector is at a crossroads. Changing demographics and aging population, increased rural to urban migration of indigenous communities, rising income inequality, and the record number of immigrants and refugees are all increasing demand for programs and services. So this growing demand for services is already straining capacity. I was in a presentation or a session last week in Saskatchewan where they showed a graph where expenses for new services are vastly outpacing revenues. And there's a crisis essentially moving. A sluggish economy is putting pressure on governments and affecting how they work with, think about, and finance charities and nonprofits. There's an increased focus for many of you already know of streamlining operations and finding efficiencies, and there's also greater focus on outcomes for different outcomes. So these shrinking core budgets, we've talked about funding as a critical issue, but these shrinking core budgets could impact salaries and other employment conditions that contribute to parity in the sector. We've heard and there's been much written about the fact that our current systems and structures, policies, and legislation could be viewed as risk averse, outdated, or constraining. So, Brian Emmett is a chief economist in Canada. He talked about this looming social deficit, and it ultimately will mean that there'll be unmet needs in systemic issues in the not-for-profit sector. So our view is that we wanted to understand, so what do we need to understand together to support change? And I love this goal because it really reflects low energy state and how we're approaching this issue. So creating change requires a thorough understanding of the problem as well as the appropriate skills to address that problem. And so our take is that we can make progress on very specific components. So to solve these big problems, we want to break them down into smaller components.
Lisa, you asked for a 5-minute one.
Okay. So we actually launched an enabling environment series, a series of papers to look at first defining what an enabling environment means, because although it's been talked about in an international context, in the Canadian one, there was this debate and discussion of what does that actually look like, what does that actually mean. So defining it and then unpacking the different dimensions. And we're intended to be context pieces to support public policy discussion and development. And my disclaimer, because we're in this audience, is that we recognize that there are many windows in which to view the sector and its challenges, and this is really one of them. And so we started with identifying a definition for the relationship of an enabling environment. So we wanted to start with a vision, and we built off of the work of the Accord and Voluntary Sector Initiative that looked at, that recognizes the sector's important role in contributing to people's quality of life. An enabling environment one is where the government invests in the growth and success of the sector and consults key stakeholders on their priority needs and safeguards public interest, supports the sustainability of the sector, and optimizes the policy landscape for innovation and experimentation. So there are components, we identified specific policy areas and components within these. that we sought to unpack to provide context. So what is happening, perhaps why, and identify possible ways for section and government to work together. Some of them being regulation, climate and funding reform, and data information. And our vision for an enabling environment would be one that took it from the current state of fragmented, confusing, outdated, siloed, restricted, reactive jobs to one that was integrated, transparent, outcomes focused, engaged, innovative, evidence-based, and sustainable. Yeah. So are we turning a corner? It depends on who you ask. Some will say no, we're not. We haven't addressed this other issues on the regulatory side, and we're so far and we're so outdated. But in fact, some of our work so far has surfaced some really interesting examples. And so I wanted to profile a couple of them today. So one is around enabling legislation. So in Manitoba recently in September, they passed the Protecting and Stolen Information Sharing Act to help authorities find misinformation faster and provide better care for our disputes. Basically, it allows for greater information sharing between agencies. And similar legislation was passed in Alberta in 2015 with the Children's First Act. And so a big barrier that I've heard from the agencies is that when they deal with children, there's a perception of good share information. It is addressing that. Okay. Grounded data and infrastructure models. So there's an example of, it's not just important to be able to share data, but it's really to actually use it, to understand it, to have the capacity and literacy to understand what it means to shape how we work. So here's an example of using shared infrastructure, policy laws, panels, and youth data laboratory. So they're managed by a nonprofit organization, policy-wise. It's one example of an effective partnership between government and the sector to centralize data. The data laboratory is identified as part of this Children's First Act. They act as a lead data partner, and they receive anonymized administrative data to analyze, conduct research, and publish online for policymakers, practitioners, and the public. This type of infrastructure would be highly beneficial to the sector. Another one that's surfacing is discussion around engaging end users in search for what works. The Americans and the UK have been leaders in a new type of evidence institution called the What Works Center. There are a lot of evidence institutions doing fantastic work, but this one is unique for two reasons. One, it actually generates information, generates research, but it translates it in a way that's accessible to practitioners and policymakers. And the What Works Centers are independent from government and directly connected to policymakers. So they're finding that these are effective tools to bridge the gap that often exists between research and practice. And What Works the What Works Center model is also unique because at the heart of the model is engaging end users. So end users are defined as both practitioners and beneficiaries in some cases, and policymakers. So they are involved in setting the research agenda, identifying the research questions, and actually working to get the successful interventions into practice. The next one is the one called Voices project. This is a really interesting example of an organization out of Winnipeg dealing with a community that's a very impoverished community. It's a social innovation initiative in Port Douglas area. It's community-led, and it's a partnership with the Manitoba government. And at the heart of it, they place their program and their support with the child at the center. So they took a community-based approach to prototype or test solutions to determine their effectiveness to achieve their ultimate goal, which is to dramatically improve the well-being of children and families in all aspects of the self: physical, emotional, mental, and spiritual. So they built a child-centered model with some best practices in partnership with the community, with service worker organizations, and with the government. Okay. And the final one, which is sometimes a little bit contentious in the sector, but it's in the area of outcomes funding arrangements. And the government of Canada's forthcoming social innovation and social finance strategy will likely increase the profile. Internationally, these are proven to be effective at moving towards outcome outcomes and job efficiencies. So they're basically a tool where service delivery organizations are financially rewarded for long-term impact on service users. The government of Saskatchewan is one example where they just launched their second social impact bond with the Mother Teresa School working with Indigenous youth and having success so far. What I tried to do here quickly was to identify that there are bottom-up approaches that put people, and specifically in these examples, children, at the center of their models to inform and shape their work. And in doing so, it's informing and shaping policy, in some cases legislation, regulation, and ideally a broader administrative practice. And in this way, it can enable and shape the sector, and more importantly, improve quality of life.
Thanks so much, Lisa. We're now going to move on to Sydney Riegel, who's already been outed for his great fashion sense today, his vibrant green. But as Pearl noted, very fitting. Sydney, as I'm sure pretty well everyone knows here, Sydney founded, then he chaired the board of directors, and then for close to 20 years now, I guess, has been the executive director of EquiTab, Canada's premier environmental organizations, and has recently become an active and much appreciated member of the Voices family. So, over to you.
Alors, merci beaucoup. Bonjour tout le monde. À vous de discuter en English. Je vais quelques mots en français pour s'il y a par la suite des questions en français, pour faire plaisir de répondre. Plus de monde qui parle anglais, je vais continuer en anglais. Alors, so I'm going to talk to you a little bit, a bit of a different angle than Catherine, but very complimentary about the Revenue Canada and charitable issue here in Canada. So very quickly, for those, just to make sure everybody's on the same page, this all started, this whole debate in Canada, the recent part of the debate, because Canada's one of the major oil exporters, right? We export millions of barrels a day of oil. And we sometimes forget that up here in the East, but Canada is a very important exporter. And a lot of that oil, an increasing part of that oil is from tar sands, which is part of one of the most carbon-intensive oil in the world. And for that reason, environmental groups in Canada and now throughout the world have been campaigning for Canada, and this has precedes the previous government, to stop developing and eventually reduce the production of that oil. The previous government, the Harper government, was very much in favor of the development of tar sands, as was the one that preceded him as well, but they were just more very bluntly in favor. And proceeded as of the end of the 2000s, beginning of the 2010s, to become very, very vocally opposed to any organization that would say that we should stop producing or stop developing, I should say, oil sands in particular. And this was translated into media attacks. So environmentalists were treated by ministers of the previous government as being terrorists, as being groups that were anti-patriarchal, and so on and so forth. So there was an active debate of denigrating environmentalists and anybody who was in the space. And at some point, I think somebody within the government said, hey, you know what, there's a way we can attack these environmentalists more directly. And it's through the fact that most of the environmental groups have charitable status in Canada. And so in 2012, when the government finally got a majority in their first budget, they gave, I think it was $8 million extra money to Revenue Canada to go out and do political audits. That's how it was framed by the government. And so the political audits refers to the fact that in the legislation, there was a restriction on what we can do as charities with respect to public policy, but they refer to it as political activity, which is very, very confusing, but what's supposed to mean is policy work. And so they went out and did these audits. Kitao was audited. Our audit lasted for 4 years. And it just ended this year, 2017. As were many other groups. Some groups are still under audit. So some groups have been audited for over 6 years. And what the minister did recently was to suspend those audits. She didn't end them. So for many groups, there's you say this in English, the sword of Damocles, which is still above their head. So this is not, it's far from being over. And the reason, so let me just give you a quick example of the policy chill with Dissent. So, and as Kathleen stated, this legislation predates Mr. Harper. He just used it. But basically what it says right now is, if you're an environmental group or any group, any charity, and you're invited to a parliamentary commission to testify on legislation, proposed legislation, that's considered by CRA as a charitable activity. If you then leave the parliamentary commission and talk to media about what you just said, that's considered political activity that you then have to account for. So you need to count it. Now, what do you count from an accounting point of view is extremely vague. So you need to account for all the information and research you put into testifying before the parliamentary commission. Some lawyers will say yes. Some lawyers will say no. You just need to account for the time that you spend talking to the media. So that's very ambiguous. And then if in your comments, if you say, I very much appreciated the Liberal government's comments on this legislation, then you can be accused of being partisan, which under legislation could get you to actually have your charitable status revoked. So these are 3 levels of public policy that anybody who does public policy work needs to do. You need to do all 3 at some point to actually be effective. And yet it's very unclear and murky where that line comes to be drawn. So the effect of that work, even before Mr. Harper, there's many charitable organizations, including UTI, often hesitated to do policy work because we did not know, like, what can we do and when can't we do? So I'll stop there on that. We did make a lot of wins. So we got many political parties during the last election who promised they would change the legislation. The Liberals were one of them. They have it in their mandate letters asking the ministers to change the legislation. They actually used the words in the mandate letter, stop harassing charities, which I think is interesting. And if there are lawyers out there, I'd be interested in getting your point of view on, we had actually a case that they're sort of admitting the government harassed charities. Anyway, so there was a consultation. The panel report came out, basically saying what we're all saying here: you need to change the legislation. And now there's been nothing. And there's a lot of hesitation to go forward, and a lot of us are doing a lot of work, but not enough of us to try to get this government to prioritize this. Because basically the issue is they promised the whole. They have hundreds of promises basically, and this one is just at the very bottom. It's not front page news, so it's staying at the bottom. That's the issue we have, and we can come back to that. But with the 2 minutes I have left, I'd just like to make a couple comments in terms of what the overall objective of our sector should be around this. And the conversation in Canada is very much comparing us to other common law countries who have this charitable concept, right, which doesn't exist in civil law, for example. So I'm a civil law lawyer by training only, but I don't practice. So take my comments with a huge grain of salt. But this idea that we need to keep this fiscal exemption for nonprofits within the charitable framework, for me, makes no sense. There are many other examples of exemptions, including for the charitable sector, where there's actually no other constraints that come with it. So the most obvious one to me, anyways, is the exemption in property tax. So if you're a nonprofit, if you're on a certain list of activities that you do, you get an exemption for your building. Now, I haven't been able to find numbers on this, but I think the exemption in Canada for nonprofits that have buildings probably costs more than the exemptions that we give for charities for donations. Yet, there's absolutely no restrictions in terms of what you can do as a nonprofit, right? Because there's absolutely no link between the fact that, we should subsidize nonprofits because they do public work, and we should restrict how they do that work, or we should restrict what they can say or can't say. That makes absolutely no sense to me as a computer. And basically my point is, I put this out as a talking point. It's not necessarily our position when we're lobbying around this, but as a sector, shouldn't we be much more ambitious in terms of what we're asking for reform around this tax exemption, which we call charity law, but which other countries just call a tax exemption, to reinforce our capacity for the sector. Thank you.
Okay, just going to Sydney, 10 minutes exactly. Et maintenant, Mercedes Roberge. Mercedes travaille et milite dans le milieu féministe et communautaire depuis plus de 30 ans. Depuis 2007, elle est coordinatrice de la table de regroupement provinciaux d'organismes communautaires et bénévoles. Et elle siège depuis 2016 au conseil d'administration de la Fédération des femmes du Québec. Merci.
Merci. Je vais démarrer la présentation. Je n'ai que quelques éléments visuels en présentation. J'imagine que vous ne connaissez pas beaucoup la part des regroupements provinciaux, donc je vais la présenter maintenant. Nous regroupons 43 regroupements provinciaux. 43 regroupements provinciaux qui réunissent 3000 groupes au travers le Québec. Des groupes qui sont actifs sur différents enjeux liés à la santé et aux services sociaux, donc aux déterminants sociaux de la santé. Vous en avez quelques illustrations ici, ça va de la sécurité alimentaire au soutien aux femmes et aux enfants victimes de violences. Donc, à l'écoute, le soutien aux personnes pour défendre leurs droits, bien entendu, proches aidants, très comme l'image de niveau, voilà le membership de la part. Alors, je ne vous épargne les 3000 logos de leurs 3000 membres. La table est aussi très active dans les mouvements sociaux. Alors, voici quelques-unes pour illustrer la journée quotidienne et celle de ma collègue, parce que nous sommes que deux. Nous sommes membres de la Ligue droit et liberté, nous sommes membres de différentes coalitions, la coalition Solidarité Santé, nous sommes actifs dans des campagnes qui touchent particulièrement les mouvements communautaires, comme par exemple la campagne Cash, qui vient de lancer pour le financement et l'économie des groupes communautaires qu'on représente, mais aussi pour des enjeux sociaux comme l'assurance médicaments, 100% public, c'est toute la population. Et au centre de ça, la campagne dont la publication de favori, qui est Mon OSBL n'est pas un mot. Je l'ai mis au centre de toutes nos actions parce que c'est au cœur de la vie d'une organisation de droit d'association. Alors, nous avons fait certaines images, elles vont dérouler au fur et à mesure. Le droit d'association, on pense souvent le temps pour acquis. On l'exerce, mais on ne se rend pas nécessairement compte, dans un pays démocratique comme celui que nous sommes censés avoir, que ça peut être fragilisé par toutes sortes de conditions extérieures. Dans ma petite vidéo, j'ai inclus des éléments personnels à moi qui montrent que je ne suis pas qu'une travailleuse communautaire, je suis aussi militante, je suis membre d'organisation, je participe à des causes, individuellement. semble, on fait partie du grand club qui soit, le plus ouvert qui soit. Le droit d'association, c'est un droit individuel, bien sûr, c'est important pour les personnes que ce soit accessible aux personnes, mais c'est important aussi que les organisations existent. Pour que ce soit, parce que c'est également un droit collectif. Des choses qui sont évidentes pour plusieurs d'entre vous, mais que nous, on a intégré dans nos les personnes qui vont dans les recours aux organisations, aux associations, le font pour toutes sortes de raisons individuelles, mais globalement, on le fait pour se donner plus de force, pour se donner les moyens de vivre la vie démocratique, d'être actif et active, individuellement et collectivement en démocratie. Et pour que ce droit-là individuel existe, bien, non seulement il faut que des lieux existent, mais il faut aussi que l'État ne compromette pas l'existence et le développement de ce lieu-là. Et bien sûr, on n'est pas on ne se fait pas ici emprisonner pour participer à une manifestation, on ne se fait pas, notre vie n'est pas en danger, mais ça ne veut pas dire que le droit d'association, lui, ne peut pas être. Alors, mon EPL n'est pas un lobby que vous voyez défiler tout à l'heure. On a créé cette campagne-là pour s'opposer à une intervention des intentions du gouvernement et du commissaire de l'organisme qui veut assujettir tous les OSBL du Québec à la loi sur la transparence et l'éthique en matière de l'organisme. La loi québécoise, donc la loi fédérale également, que vous devez connaître, vous connaissez peut-être davantage. Il y a une citation de la juge Claire de l'Héroïde que j'apprécie particulièrement, qui est l'interaction des individus entraîne un élément de synergie dans la société. La simple addition d'objectifs individuels ne suffit pas. La société est plus que la somme de ses parties. Autrement dit, une rangée de taxis n'équivaut pas à une. Nous sommes les deux. Alors, la loi existe depuis 2002. Elle a été conçue à l'origine pour, dans un contexte de crise, dans un contexte de scandale, c'était le scandale des commandites à ce moment-là. Et elle a été créée dès le début pour rendre transparent les relations entre le public et le privé, le privé d'affaires. Dès le début, il a été dit que il fallait traiter différemment les interventions vers les titulaires du champ public, les interventions suivantes, qu'on fait avec ou sans effet, mais qu'on fait. Il fallait les traiter différemment lorsque les intentions avaient un but collectif versus un but économique, des bienfaits personnels, l'intérêt économique d'une personne. Bien entendu que les organisations de la société civile ne sont pas là pour faire des gains qui servent des individus et encore moins des gains économiques. Depuis 2002, depuis la création de la loi, les lobbyistes inscrits, les lobbyistes, appelons-les les lobbyistes du monde des affaires, se sont plaints d'iniquité. De leur point de vue, l'entreprise qui veut faire du développement économique peut inscrire ses interventions comme lobbyistes, mais pas les organisations environnementales qui les empêchent. Alors, ils trouvaient ça inéquitable, et c'est un exemple qu'on nous voit souvent c'est vrai. Les ministres qui ont déroulé depuis ce temps ont eu une très grande écoute, et le commissaire de lobbyisme a aussi été très sensible à ces arguments. Ce qui fait que depuis 2002, le commissaire particulièrement de lobbyisme tente d'assujettir tous les OLB à la loi sur le lobbyisme. Il y a eu à différents rapports, à chaque année, à chaque 5 ans, quand on fait des rapports, il y a des consultations, on a déposé des mémoires. En 2008, ça a été la première intervention de la table là-dessus. Et à chaque fois, on est majoritaire à dire non, mais ça n'a pas de bon sens. La loi n'est pas faite pour ça. La loi est pour rendre transmettre de la lumière sur ce qui n'en a pas. Ce que l'on fait, on le crie sur les doigts, on fait des bulletins, on fait les manifestations pour le faire savoir, il y a quelque chose de plus public que ce que fait un organisme dans les mouvements sociaux. Parce que pour défendre les droits, il faut que la population soit au courant de ce qu'on fait. Ça ne se fait pas derrière les autres. Dès le début, on a mis beaucoup d'emphase sur
la différence entre le but lucratif et l'absence de but lucratif, mais on a aussi au fil du temps amélioré notre argumentation en y insérant la notion de la défense du droit d'association et de la liberté d'expression. C'était pas inclus dès le départ, c'est pas dans notre vocabulaire quotidien. Et on a de plus en plus illustré de quelle manière l'OSBL serait en péril par une loi comme celle-là. Les contraintes qu'on nomme, de les nommer comme aussi pour montrer leur absence de proportion qu'elles occupent. Et de plus en plus, cet argumentaire-là nous a aidés non seulement à faire connaître la campagne, mais aussi à la sensibilisation des groupes eux-mêmes sur l'importance, et peut-être que c'est plus important que ça d'ailleurs, les groupes eux-mêmes ont senti qu'il fallait défendre le droit d'association. C'était trouvé en bloc. Alors, on a, entre autres, parmi les activités, évidemment, depuis 2014, je l'ai dit, depuis 2014, on est en campagne, on a réuni environ 150 organisations très différentes les unes des autres, dans les différentes 2 rencontres par année à peu près, mais les actions qu'on a faites, elles ont eu une plus grande portée encore. Entre février et juillet 2015, notre première vraiment année, une lettre signée par 30 OSBL, suivie d'une autre signée par 1100 signatures, donc 680 organisations. Et en juillet, après une pétition qui roule durant l'été, vous imaginez que c'est pas gagnant comme manière de faire, quand même 8500 signataires à une pétition sur un sujet aussi aride, quand même, pour le Robert. On a martelé tout ce temps l'idée que l'assujettissement de tous les USBL à la loi allait compromettre le sujet, allait nuire à la liberté d'expression, allait limiter la participation citoyenne, et ça allait conséquemment dénaturer la raison d'être des USBL. Ça allait même dénaturer le registre des USBL, parce qu'on allait inonder ce registre-là d'informations redondantes. Toutes les coalitions dont vous avez vu, il n'y a pas une qui nous semble là-dessus. Il y a plein d'autres organisations qui participent aux mêmes actions. On aurait tout écrit la même affaire. Donc, inonder pour rendre peut-être moins visible les vrais faits qui devraient être mis en lumière. Que ça allait être une charge supplémentaire et une limitation importante du droit d'association individuelle. Pour être une association, il faut avoir des membres. Au conseil d'administration, il faut des comités. Pour avoir des membres, il faut que les personnes qui s'y impliquent aient une satisfaction à l'égard, pas une charge supplémentaire de s'inscrire, de se voir, surtout un problème de vision, de se voir comme un lobbyiste plutôt que comme un militant ou une militante d'une organisation. On crée énormément de, du coup, avoir de membres, et puis, du coup, avoir des gens qui veulent s'impliquer vraiment. Donc, pour l'instant, on a, dans les gains, quand même, réussi à interrompre le processus parlementaire. Il y a un projet de loi qui a été déposé en juin 2016 et qui n'a toujours pas été soumis à la commission des institutions. Et il n'a pas été soumis parce qu'on a montré que c'était problématique pour les gouvernements. Et on a réussi à le faire en montrant aussi aux groupes que c'est par leur complémentarité et par leur diversité que, quand on se met ensemble sur une cause commune comme celle-là, qu'on peut montrer à quel point on peut mettre en valeur l'importance et la richesse du droit d'association pour une société. Alors, pour nous, c'est important de redire que les milliers d'organisations et les dizaines de milliers de personnes qui en sont membres ne doivent pas aujourd'hui comme des lobbyistes, bien entendu, et que nous avons le droit de faire des interventions pour améliorer les politiques.
Excellent. Merci, Mercedes. And we're now going to move to our last presentation, which will be Mathieu Vic, who is a researcher with the Canadian Union of Public Employees Quebec branch or division. And in that capacity is very active around a variety of issues, in particular on privatization and outsourcing. But you will have noticed in his bio that what we really want to understand is how he is going to draw on his PhD in astrophysics. And it may actually be through that lens that we get the solution to all of this. So, over to you, Vincent.
I often make a joke about that, rather than break the ice, but I will start by prefacing my comments with the fact that I'm not an expert on this. I was joking earlier that the enabling environment is something that I have not put too much thought into, and I'm actually replacing my director who was supposed to be on this panel. I'm replacing him 2 days ago. But having read the working paper, the enabling environment is intimately linked to things that I think about a lot, actually. So I will talk about those things. So thanks for having me. I think it's important and it's a good thing that you guys have made room for organized labor here, or maybe we made room for ourselves by being a funder. I'm not sure. I think that
They were saying earlier, grab the
I think that for some time now, maybe decades, and maybe we can point to Thatcherism and Reaganism as some type of breaking point, the vital and intimate relationship really between organized labor and civil society organizations fighting for social change has been fraught with a lot of distrust, a lot of indifference. I know that there's at the very least a perception in the general public that unions, at least now, are out there to protect the members, and that's about it. I think some of that perception is our own fault, and for sure all unions don't speak from a same voice. But I think conversations like this are important to, try to rebuild some of that relationship and try to have some of those bridges, because if we really want a truly progressive agenda in the face of the really powerful forces for status quo, I think we kind of need all the people we can get, and I think that is, having labor and civil rights organizations working together again or more is a goal that we should strive for. So maybe I can talk just about labor a little bit. I don't think I'm going to. I think you guys are all aware, hopefully all agree, that labor, organized labor, have been leaders for many social battles. First off, obviously, with workers, unions have been there to reduce social inequalities by fighting for better wages, benefits, pay equity, health and safety, pensions, anti-harassment laws. But also in the broader public. I mean, unions have been there as some of the leaders fighting for social justice issues, including, equal rights for women, minorities, LGBTQ community, people with disabilities, First Nations rights, and also for, protecting and maintaining public services that we all depend on. And I think something that's important to know is that, a lot of this change is actually, or some of this change, I should say, is obtained through collective bargaining. A lot of anti-discrimination laws are anti-discrimination clauses in our collective agreements first. Or some of the anti-privatization and anti-subcontracting clauses in our working collective agreement contracts are what protects the public services that, all of society, and especially our most vulnerable, depend on the most. But outside of the bargaining table, the unions, and that's basically most of the work that I do a lot of advocacy outside the workplace, and they fight on campaigns, whether it's Fight for 15, which we've been hearing about a lot lately, or whether it's for, more protections for refugees, or if it's for a national pharmacare program. So there's a lot of that advocacy work that is done by unions. Some of it is done through member mobilization. A lot of it is done through coalition work. I work a lot with coalitions. But some of it is also done through direct financing of civil society groups. And I think this conference is maybe an example where labor has tried to contribute to these conversations, if not by mobilization, through direct financing. So I think with that in mind, I think it's fair, I hope it's fair to say that legislation or legislative measures that hurt workers, or their right to bargain collectively, or their right to associate freely, directly hurts civil society's ability to fight for social change, directly and indirectly, actually. And I what I was trying to say earlier, and I think you guys will agree, labor is, or at least it should be, a big part of the voice fighting to challenge the status quo. So in that sense, I think it's clear that the Liberals' repeal of Harper's anti-worker C-344, C-525, those are positive steps for sure. But there are other measures that still exist that can hurt as much. And I was reading this 2 years of the federal Liberals, and they talk about some of these things I want to talk about. Harper C-51 is not being completely fixed in the Liberals' new C-59. Disrupting threats that interfere with the economic and financial stability of Canada is much too broad. Does that mean that some strike action could be, intervene? We could intervene with strike action and things of that nature. I think there's work to do on that. The Liberals' current transparency bill focuses a lot on proactive disclosure, but not on actual access to pertinent information, which will empower civil society and journalists to critique public policy and to try to, challenge the status quo. The Liberals have, a slew of privatization bills, like the Canadian privatization, I call it privatization bank, but the Canada Infrastructure Bank, where we've put out a paper recently where the access to information, again, will be severely impacted by, and I could talk about the Canada Infrastructure Bank in bad terms on other issues, but just on access to information and empowering civil society, there are big problems. So amending all those specific laws is definitely a way to help CSOs both directly and indirectly, but I think that it's also important to talk about some of the macro things. There's some of the micro things that we have to keep working on, but if we don't work on some of the bigger, broader macro things, I think we may get lost in the shuffle. And I don't know if it's an elephant in the room in a sense, but I think it's vital to talk about the fact that our current neoliberal system completely undermines CSOs, disenfranchises voices trying to fight for social justice, and has a lot of perverse effects. And by neoliberalism, I mean austerity, free trade, tax cuts, privatization, outsourcing. I had many thoughts on this. I have probably like 4 minutes left, so I will try to concentrate on 2 examples to illustrate this point. I'm going to talk just a little bit about free trade, and I'll talk a little bit about the Réseau électrique métropolitain, which is a new privatized train that they want to build in Montreal. I'll talk just briefly about free trade. Everybody here knows what ISDS is, investor-state dispute settlement. It's the famous, if you want, it's the famous Chapter 11 that we've heard of NAFTA. It's a tribunal which essentially lives above the national laws. So let's say you're a mothers group or a First Nations group or an environmental group, and you're fighting for a ban on a known neurotoxin called MMT. And then you fought for years and years and years. You've done the public advocacy, you've done the lobbying, you've done everything you had to do, and finally you obtain a ban on MMT from the federal government. They enact a law which is a ban, which is a great thing. Well, Ethyl Corp, which is an American company which produces MMT, goes through Chapter 11 of NAFTA and sues Canada because it's affecting their profits. And the ISDS tribunal of NAFTA says, Canada, you have to pay Ethyl Corp $14 million in penalties, and you have to rip up the law which was enacted by a democratically elected government trying to protect the environment and its own citizens. So, for me, it's clear that when you put mechanism that puts profits above democracy, above human and environmental rights, this completely disenfranchises civil society and denies them the power to affect change. And there's also a huge policy chill element to ISDS. So I think that we have to keep fighting on trying to improve laws that strengthen CSOs, but I think we can't lose focus, and we have to keep an eye on some of these bigger things that are also affecting civil society. And the last example I want to talk about is Montreal's new Réseau électrique métropolitain. So whereas transit usually, traditionally, is planned financed and operated by the public sector. It's been built for years by the private sector, but it's planned, operated, and financed by the public sector. Because of austerity, because of neoliberalism, now we have a new train that is planned, that is financed, and that is will be operated and maintained and owned by the private sector. And because of this, there are many, many perverse effects to designing of what should be a public service. We should be designing a public service to try to address needs, but now we are designing a service to ensure that we have enough profits for, well, in this case, the pension plans. And some of the perverse effects, I could talk about this for the next 5 hours, but one of it, for instance, they're going to spend $1.2 billion to destroy a line, an electric train that actually runs right now, du Montagne, which is full, in which we could double the capacity with new cars for $100 million. We're going to destroy 12 stations, rebuild it with another electric train and another technology, but at rush hours, the capacity will be the same or maybe slightly larger, but most people will have to be standing up on a 30-minute ride, for instance. So these are some of the weird things that can happen, and I could keep going on and on and on. But what I actually want to talk about is this: how. So in Quebec, we have the Bureau d'Audience Publique pour l'Environnement. So this is an institution that, an institution, if you want, that is an environmental review board that looks into big infrastructure projects and says yes or no, we should go forward with this project based on environmental, but also social and economic. The law says also social and economic factors. And like the environmental movement has fought for this thing for a long, like it took a while to get it. This is a huge victory, and a lot of jurisdictions should be jealous of this institution that we have in Quebec. So the BAP looked at this project and said that for many reasons it didn't pass the test. It did not get the stamp of approval from the BAP. They said that the developers did not look at urban sprawl. They did not look at the negative impacts on the current train. They did not look at all the emissions that will be generated through the construction. And what was so disheartening is that the government, and this is something we have to think about, is that we have laws and we can strengthen laws, but sometimes the government doesn't care about what the laws are. So in their new Voices-Voix, the Quebec government not only just goes over what the BAP says, but also reduce some other things that we had fought for, like public consultations on development. They have eliminated or cut days of public consultation. They had cut by half almost the number of days for the environmental review. They've also cut appeals for expropriations, and they've said retroactively that all the development will be sometimes I struggle between the two languages. That all new development will be okay with the environmental laws retroactively. So I'm going to wrap up. I have about 1 minute left. So I think that
that's the astrophysicist in you coming out.
So I think we have to think about that too. When we strengthen all these laws, and the governments just don't respect some of the laws that we've put in place and some of the mechanisms we've put in place to protect the environment and to protect civil society, etc. And just to kind of finish my loop about neoliberalism, neoliberalism has deep roots even in civil society groups. Some environmental leaders in Quebec actually discredited some of the things that the BAP said when the environmental movement fought so hard to actually get the BAP. I've had off-the-record conversations with some of these people that have discredited some of the findings of the BAP, and they've acknowledged that maybe it could be maybe a bad project, but really that it's that or it's nothing. And I kind of get what they're saying. I don't think it's because there's strings attached to their financing. I think that they think it's that or nothing, but that's Margaret Thatcher's favorite line. There is no other alternative. It's really, neoliberalism has entrenched even civil society. So basically, I'll end there. I think it's really important to strengthen laws and look at the micro, but we also have to keep an eye on some of the larger macro economic, financial things and forces that are affecting our enabling environment. Thank you.
Great. Thanks, Chair. Thanks to all the panelists. And that was, we wanted to leave 30 minutes, we've left 26 minutes, so that's not bad. Well done. And so we had a big question in front of us. Is there an enabling environment for civil society in Canada? And I think you saw that we really kind of did a wide tour around that question, looking at it from a question of legal analysis, from a policy research perspective, from the perspective of an organization that has certainly felt the force of some of the recent disenabling measures, and certainly the grassroots front lines perspective, that coalition view, which includes individuals working on important issues in their communities, and then not quite out into outer space, but that really important labor movement perspective, and with that, I think some important economic analysis that plays into this. And a lot of important challenges, questions. There was, I think we had both glass half empty and glass half full perspectives on this. Concerns about the lack of independence in our current regulatory setup. That hunger for where's the vision, where's a sense of harmonization, where's role clarity, where's the public interest? Who's looking after the public interest as all of this gets worked out? What's the basis for restrictions on charities in the first place? Why do we even need to go there? This big, consuming debate about whether it's okay for charities to be engaging in political activity, which, as we were reminded, is really about policy work and advocacy. How do we make sure that we're empowering individuals in the communities who, at the end of the day, are working on really fundamentally important issues at that level? The need to keep our eye on both micro and macro issues, and then a challenging question at the end as to whether neoliberal economics just inherently disenfranchises civil society organizations. So lots to grapple with, but we now have an opportunity to turn to you, whether there's particular aspects of what you heard in these presentations that you'd love to challenge or question or hear more about, or whether it simply has sparked some other ideas that you'd like to put on the table as well. Okay, so her, and then Toby, and then back to you. Okay, so there's our first five.
So thanks very much to the panel and all of these discussions. And I guess I'd like to ask a question about the role of philanthropy. And I know there's some people in this room who have a particular interest in this area. I've had conversations with some of you about this. So I've been both somebody who works with organizations that have sought funding, and I've been involved with organizations, one domestically, one internationally, who grant funding. And I would like to know on this issue of the children and the environment. So I guess this is partly some of their experiences. Whether you feel that philanthropic organizations in Canada as charities, they also have suffered from that chill, and what the kind of regulatory issues are, and whether they also kind of fall into that neoliberal mentality, if you will, that was just described earlier. Any, if you allow me the luxury of capability. Imagine going to a bank, which is of course a private business, and asking for money, and having the loan officer you actually get to sit in front of and talk to, say to you, well, we'll give you money, but we actually won't fund any of your salaries. And we want to make sure the money doesn't go to your phone bills or your infrastructure. Oh, and any ongoing costs, we're not going to fund those either. And it would be really great if it was innovative, but it would be fantastic if you actually had piloted it and run it to show us success going forward. Oh, and we want to fund sustainability, but we'll only do that for 3 years. So you actually get much more progressive response from many budgets than you would do from many private philanthropic organizations. Most of whom in Canada will not fund human rights unless you frame your discourse in a way that does not emphasize social justice and human rights. And I say that as somebody who has worked with many philanthropic organizations in Canada for whom I have the utmost respect. But it was clear during the dark decade of Alex's term that, with the exception of maybe one op-ed in the Globe and Mail during the period between 2011 and 2016, Canadian philanthropy was mostly silent. Working behind the scenes, absolutely, but mostly silent. So, forgive the long preamble, but I'd be interested in knowing from those of you who have a view on this, why that is, and do you have any insights into how individuals, governments, civil society can work with philanthropy to make it more adventurous and bold and existing in
Maybe we want to take a
You said 3 or 4
philanthropy?
Yeah. You can pick any one of these.
I think it's stab at it. I mean, it's one of the things I didn't talk much about. But I mean, in terms of, what kind of funding should we be looking for as organizations, as a movement, to do what? I think that's at the heart of your question. So I mean, if you're, the vast majority of the nonprofits in this country are providing services, direct services somehow to Canadians. And so I mean, the kind of fund, and the vast majority of funding available in this country is directed to these types of organizations that provide services, right? And I think the conversation with respect to these organizations, whether we're talking about private foundations or government funding, or even self-funding, is different than when you're talking about organizations that want to do policy work, or either as a part of their work or as a focus. I'm in Quebec, many organizations, and we've organized very, very well, thanks to organizations like Mercedes, have a lot of government funding in policy work. So it goes back to that whole discussion about, is that appropriate? I've always questioned whether it's appropriate, and certainly in the case of environmental groups, it hasn't worked, right? So I think there's certain types of organizations that it doesn't work. To respond to your question directly, why are private foundations hesitant to fund this kind of work? I think it's just a reflection of partly of just the general population in Quebec, certainly, I would argue Canada, doesn't understand what policy work is, doesn't understand what it entails. So it's a very small, our members, it has a membership-based supporter list. That's where we get most of our funding now. But I mean, I think they have some sort of understanding of how policy works, obviously, because they're supporting us to do that. But I think the vast majority of people don't know, and therefore the vast majority of people who work and who have created private foundations don't really understand that. And I'll end on this, but one very clear example is there are organizations that do conservation by trying to convince government to protect land. And there are organizations that do conservation by buying land, right? And my colleagues who work in the first type of organizations always say, like, we're 10 times more effective. Like, for every dollar you give us, we'll protect 10 times more land, obviously, than when you're trying to buy land. Because it's a much more bigger leverage in its government to use its power to protect public land or even to buy private land. But the vast majority, 9 to 1 of the money in the environmental sector goes to organizations that buy land. And I think that applies to almost every other institution.
If anyone else has maybe one other quick intervention on this?
Well, you go ahead. Just to add to that question of why is philanthropy Canadian silent. I think there's a huge, in my experience, I've been out of practice a few years, but there's a huge risk aversion that goes beyond just the organizations, but to kind of political advocacy. And part of it is that the consequences of getting on the radar, so to speak, and messing with the charity sector in another way are so severe that people with big money aren't willing to do it. And your legal advice is going to be, if you want to do anything risky, you start another organization, do it out of that organization. So if you get taken down, it's isolating and mitigate your costs, right? And so I think that's a major, and I'll just add that no one has won. So when you get your charitable status revoked, there is an appeal route to a federal court of appeal. No one has won a revocation appeal in something like 18 years. People have just stopped. Because no one ever wins for a whole bunch of reasons that I can talk about. And so your legal advice is going to be just do the workaround, just mitigate your risks, don't even go there. And I think that's a big point.
I do want to add.
Yeah, real quick.
So I heard a couple of different things. I do think my perspective is that there are some, quite a few foundations that are in this issue, so I disagree. Particularly on the concept of broader sector reform, looking at multiple issues around the regulatory barriers. So I do think they're engaged. I think that there's another question here, which is, I think the Magic Canada did a report in 2016 that looked at the survey of charities and their political activities. And what it found was that 33% were actually doing some kind of political activity, but only 3% were reporting. And so there was this question of, they probably, a lot of charities just don't understand the rules, the definitions, and so there's an issue of education as well as perhaps the rules change. But then if the rules changed, given all the other issues that I've highlighted, including a good point you made earlier, the shift from the way youth are engaging or seeing how they're actually engaging in charitable activity, not necessarily seeing a need to go through existing corporate forms, existing charitable corporate norms. And a decrease in or a change, a shift in how people are even volunteering with organizations in a sector that's so reliant on volunteering. So with all these issues of increased precarity and changing for funding, project-based, focus on efficiency and outcomes, will the rules for political activities, will changing those rules truly be a significant driver of creating an enabling environment? Question. And what underneath this question is this bigger question that no one really wants to talk about or ask, which is, how is charity, how is our concept of social good in Canada changing? Some say that it's changing from a gift model, where it exists between sort of market and state, and it's changing to a contract model. Whether we like it or not, whether we have an opinion on it or not, it's we have the entrance of market-oriented actors through social finance mechanisms and investing, and in volunteering, we're seeing people wanting to give to get something back, and there's a shift. And so I heard you actually talk about a shift in giving, and in the last 20 years, there's been a focus on efficiency. So because there was this huge, and my take on it is that there's a greater emphasis from the outside looking in on what makes an organization efficient. And are you wasting money? And so in the absence of having a broad sector organization that can on behalf of the sector to say, this is what efficiency means, it became around low ratios. And then the funders started looking at, well, that's not an effective way of measuring efficiency and effectiveness, so then we're going to shift to outcomes. But the problem with outcomes is that depending on the actor, you have very different definitions of what outcomes mean, and very different ways of actually judging proof of outcomes. So it's a very complicated question, and the answer, a lot of people think about support funding, which unfortunately is just it's not going to be a reality in the sector again. I don't think.
Thanks, Lisa. Okay, so question number one, the combination of a very thoughtful question and 3 great responses took us 15 minutes. We've got 10 minutes left, and I already have 4 people lined up, so you get my point. So Toby, quick question, and then I'll go to you. We'll do them two together. and then some really quick responses, and then hopefully we'll be able to get the next two in as well before we break.
So firstly, I think certainly your point about distinguishing between sort of advocacy groups which may advocate for services or for other things and provision of services is a crucial one. And that comes to my first point about the very definition of
You get
charity.
1 point.
So my second point. But can I suggest that we take all of the questions, because that's the only way we can get more efficient.
Okay, sure.
That's not my first point. Okay, so when it comes to regulation of charities, as we were preparing our submission for the consultation around that, it struck me that a lot of parallels can be drawn between regulation of freedom of expression and regulation of the media and regulation of charities. And both of them are regulating a human right, with all of that entails section 1 restrictions on whatever. Catherine mentioned about the independence, and in the media sector, it's absolutely ironclad established that the regulator has to be independent, and every democracy sort of abides by that, and that immediately carries over to the charity sector. And I think that a lot of those kind of rules, and one that I'd like to ask your opinion on. So you mentioned about the sort of if you praise the liberals for doing something that supports the charitable work, that's direct political advocacy under the current rules, which is a total bar. In the media world, broadcasters are not allowed to be politically partisan, but the way they apply that rule is that they need to be balanced and impartial over time in their report. So they can report the good things that a party does, the bad things, whatever, but over time. And in our submission, we suggested that that rule might be appropriate for charities as well. So you can say that things are deliberate, but you can't only say that things are deliberate over time. I wonder whether you think that would be good.
Okay, thanks. Yes.
It's just a question sitting here in the law school and having lawyers, formal lawyers, and should be learned. I ask myself very similar question, perhaps single sentence. Shouldn't our Canadian and provincial wage charter protect political expression by charity? And I'm just wondering if that how that is tested in a very simple way for health courts to actually draw a line that is decided in an independent condition as opposed to decided by governments based on considerations that aren't necessarily the entire considerations that should be brought into focus. Is it
Thank you. Ravi?
my question is quick, the sense that 6 question for about years, there was one point, very brief comment, almost on the side, where you talked, it's something about a pension plan. I know there's a paper literature that deals with this whole idea of addressing everything you're talking about by redirecting, transforming the nature of pension plans. I think Ontario teachers is a famous example, and they're going on buying massive assets. There's lots of money in pension plans. There are people that have advocated transformation of how you use pension money to challenge corporate power. I'm really good on that.
And then last year,
My question is that we've heard different, across the panel, different mechanisms for either consultation on policy or evidence-based policy-making processes and mechanisms. And I'm curious if the panel could comment on what you think the role of Parliament is in those processes, of what parliamentarians should do.
Okay, so for everything, it's okay if we kind of slip maybe about 5 minutes into lunch, yeah? Okay. So we've got 4 great questions here. This idea of when we think about partisan political activity, what about this idea of moving towards adopting a test that should be assessed over time? The question about rights charters and their capacity, federal and provincial and territorial, I guess, to be a source of protection for political expression by charities. What about pension money? The ways in which we could be leveraging that, and then the role of parliamentarians. So why don't I maybe go down the group, and we can kind of wrap this into your final thoughts as well as we complete the panel. So we'll start with you.
Maybe I'll just kind of pick the question about charters or some kind of human rights law protection for expression by charities, and talk a little bit about the problem in that regard. I think there is a case going on right now in Ontario where there is some attempt to say that the restrictions on political advocacy under the Income Tax Act are contrary to Section 2A, so freedom of expression under the Charter. The difficulty that, and not being directly involved in that litigation, the potential difficulty is that you get into that, well, organizations can say things, just not the funded ones. So it comes into this, is this turned into a positive right to government funding or platforms for, and that's a much harder argument to make, it's human rights argument. In Australia, they've taken a different tack, and I think this is, and some of you may have heard of the Aid Watch decision that was rendered by the highest court in Australia, the High Court of Australia, a couple of years ago. There's this notion in charity law of the public benefit, and that one of the criteria that one has to meet in order to be a charity is that it has to be for the public benefit. And the origin of the political purposes rule is actually that the courts cannot say that it is for the public benefit for an organization to change the law. So in its origin, the political purposes rule is actually about courts assuming a posture of deference towards the legislature, right, which is something we talk about a lot in Canada. With the high, and there's a whole bunch of reasons, to object to that, and people have it, etc. But what the High Court of Australia said in a case involving a group that wanted to be registered as a charity that was involved in advocacy around sustainable development, I think, was it has to be for the public benefit under the Australian Constitution to engage in this kind of political debate. But this has to be for the public benefit in a constitutional democracy that relies on the legislature to make these kind of changes. And so I think that's a really promising way that we could go, and there are people writing about this, at least in the scholarly world now. But anyway, I'll leave it there.
Lisa?
Some of them are more legally oriented, so I know that the lawyers focus on those. But what I will say is that last year, I was involved in a public consultation out in Alberta that brought together different funders, umbrella organizations from across the country, both charities and nonprofits, to talk about this issue of an enabling environment, to identify some of the sort of top regulatory barriers, and then to decide collectively as a sector, as a way to try to create alignment on issues. Because what was happening was that there were different messages going to government from different organizations, and so there was a recognizing that you couldn't, this group couldn't achieve consensus and reach everybody. They attempted to try to bring speak together, and so one of the questions that came up is around partisan activity, and there was a clear consensus in the room that that shouldn't be something that the sector should be engaging in. And so that was one of the pieces that was brought forward. So I wanted to shift, and one of the things that we're writing about is that not everyone in the sector, across the sector, agrees that sector reform, what sector reform is, and that it's needed. And I think we talked about this last night, that the large majority of organizations that if you fit in this box that works with CRA, that, and with all these other issues, that it's not necessarily going to, sector reform isn't a priority. And I think because of the last 20 years, sector reform has been framed through legal and technical detail, which fails, in my view, to capture the hearts and minds of Canadians, right? So why are these things needed in the first place? What are we trying to actually achieve? And it's one of the reasons why I wanted to profile some of these people-centered approaches that are actually influencing policy in certain provinces and in some cases legislation. So to move forward, whether it's political activities or other aspects of legislative regulatory affairs, there's a lesson to be learned from the work that the environmental organizations did. It's not talking about how the rules were necessarily wrong. It was that the way in which they were being administered is actually affecting their democratic rights. And people care about that. So it became a hot button issue and it got on the agenda. So I think it's a matter of changing, and it's easy because when you're in it, you want to talk about the details and the issue and the process, but I think a reframing is needed for us to actually collectively move forward and achieve.
Great, thanks.
So I will talk about the pensions part just rapidly. So obviously pensions are a source of untapped capital, or could be a source of untapped capital, and I think Canada was doing things right for a while. Our pension plan, CPP, for instance, would buy up Canada federal bonds, and we would build infrastructure, but with the pension plans buying bonds. But then there was a deregulation, and because of that deregulation, and because of the fact that we are in now bonds aren't giving good yields, and we have to realize that when we financialize people's retirement security by creating pension plans, we kind of created a monster in a sense, because these pension plans, Canada Pension Plan, all these pension plans have to have high yields if we want to ensure retirement security for all our workers. But this creates a problem because now pension plans are directly investing into infrastructure instead of buying Canada bonds. And the pension plans are requiring yields of 7, 8, 9% when Canada could build, the governments could build these with 2, 3, 4% interest. So there's a huge difference. It costs Canadians much more when we have pension plans in infrastructure and when we have pension plans in services, which is even more dangerous in my view. And just to give you guys an idea of some of the basically predatory investing of some of our own Canada pension plans, which for some are a model, but if you actually look at some of the things, we just have to make sure that there's some dangerous trends that we have to make sure that we maybe talk about a bit more. Like in Chile, in Santiago, Chile, there are many groups that all of us here would feel really good fighting with and helping them that are fighting for access to clean drinking water. Well, the Ontario Teacher Pension Plan bought all the water infrastructure in Santiago, and it is now a for-profit operation for the Ontario Teacher Pension Plan. So we have to be aware of some of these things, and I think personally we have to regulate more how we use pension money, which is a source of capital. I agree, but we have to regulate more how we use that money for fighting inequalities and social justice.
Thanks. So I'm glad that Mathieu and I disagree on at least one thing, or else it would be a very boring panel, right? Well, I agree with what Mathieu just said, but I completely disagree with what he said about the Israeli technical defense. So I'm just going to do a little parenthesis. This is not debate on public transit here, but I need to rectify that I think there's two ways of seeing that. I mean, you could see it as the way you presented it. The way we've seen it is, after decades of inertia in the public transportation sector, the government has found an innovative way to use one of the most respected and strong crown corporations. It's still failed to see how this is privatization, because this is a crown corporation who is behind this project. It's like as it is doing. And this project has gotten the support of every major environmental group in Quebec to work on public transit. So that's just a parenthesis, but Mathieu and I can keep debating afterwards around. We probably won't agree. But just on
join their table at lunch.
On the question of your question on what's balanced, I think that would be for us that would be a compromise. In my opinion, there's no reason why nonprofit organization with a fiscal advantage should be treated differently from a freedom of expression point of view than any other citizen or corporation. Why is it that a private corporation can publicly say, I'm in favor of a political party, with the only constraint of the Elections Act of Canada or Quebec or of other provinces? I mean, our position in that is that nonprofit charities should be able to say whatever they want, just like any other corporation, as long as they respect existing laws that apply to every other corporation. So we don't see, although when we're lobbying right now, we're not trying to win that with this existing government, because it seems like there's a very, very strong consensus within the movement that for some reason that we don't understand, charities should have an additional constraint when they take part in public debate. And so not being partisan is just one of those constraints. And again, with the implication that if you are partisan, the penalty is huge. You lose your charitable status, right? But there are many other constraints when a charity takes part in public debate, which we haven't really talked about. For example, you need to be balanced in your comments, right? Which most people would interpret as being fact-based. But actually, CRA interprets that as saying you need to show both sides of the debate. And so when we were being audited, they're saying, well, did you show it that the climate septic side of the debate? Well, of course not, because that's not fact-based, but that's their interpretation right now. And so you would be supposed to show both sides of the debate, and that's a huge constraint. Now, I would just end on one last note. The other thing about being partisan is if a political party has a position which is not fact-based, then how can we not call them out, right? And this was the case during the Harper government. Many of the members of this government were saying things like climate doesn't exist, climate change doesn't exist. Now, how can you? Now we are a non-partisan organization. But before we got our status, we were non-partisan. But anyway, at one point, you need to be able to say that doesn't make sense. That position of the Conservative Party we disagree with, right? Which is a partisan comment, but I mean it's based in fact. So why would you not be able to say that, right? So.
Et Mercedes, les derniers mots sont à
Oui, merci. Je vais revenir sur l'idée de la balance, mais aussi sur les mécanismes et le rôle de l'État, le rôle des élus en particulier. C'est quand même important de rappeler que c'est par l'argument de la balance que l'État veut assujettir les Européennes et les considérer sur le même pied que des lobbyistes et d'entreprises. Nous ne sommes pas lobbyistes. Nous ne sommes pas égaux. Nous n'avons pas des buts similaires, nous n'avons pas des moyens similaires, mais même si on avait des moyens similaires, ça ne change pas. Donc, on s'est battu beaucoup pour défaire, mais on ne sait pas encore, c'est pas terminé. Cette idée-là, je tombe tout le temps. Et on s'est aussi fait beaucoup servir du discours de la transparence, de la transparence de l'action gouvernementale, qui était et en vertu d'un prétendu droit public de savoir, comme si c'était un droit égal au droit d'association et à la liberté. Alors ça, c'est aussi un débalancement à ramener. L'État n'est pas égal à nous. L'État a des responsabilités qu'on n'a pas. Il a en fait la responsabilité de nous permettre d'être d'exercice de citoyenneté, de l'exercice de l'association. Et au niveau du rôle de l'État, ce qu'on attend de lui, de l'État et donc des élus, c'est très difficile de sensibiliser les élus à ces différences de statut-là, les différences qui doivent exister. La loi sur le lobbyisme, je pense que celle-ci doit exister. Ça ne veut pas dire qu'elle doit s'appliquer à toute personne qui pogne à toutes les portes. Il y a déjà des exceptions sur des activités qui ne sont pas à inscrire, qui ne sont pas à déclarer, et il y a des exceptions pour les organisations de communication et des ordonnances de communication qui ne sont pas à être inscrites. Donc, ce n'est pas de choses, ce ne sont pas des choses égales. Alors, je crois que c'est important qu'on montre nos différences. Les groupes entre eux ne sont pas égaux. Un groupe qui est en train de parler de concrètes des organismes qui ont des numéros de charité, qui ont un droit de travail plus limité qu'un organisme qui n'en a pas de numéro de charité. Les groupes n'ont pas des numéros de charité, la table n'en a pas. Alors, ça a des avantages et des inconvénients, bien entendu. Donc, je pense que ce qu'il faut retenir de tout ça, c'est qu'il faut ramener à l'État sa responsabilité de nous démontrer qu'il y a une raison de restreindre notre liberté de parole et notre droit à l'association. C'est pas grave. On ne contrevient pas à l'ordre public. Il faut le forcer forcer à vivre ça.
Wow, so Mercedes and Sydney and Mathieu and Lisa and Catherine, you've taken us many places. We've been up in sort of big questions about where's the vision for the sector, and we've been into the intricacies of rapid transit in Montreal, and many important places in between. I'm sure you'll all agree with me that we've had a rich exchange, and we've benefited tremendously from these 5 individuals' great experience and insights. So please join me in offering them a round of applause.